Okay folks, Alex Woods here, civil litigator. Now the very first thing to say is before you actually bring a claim, obviously you want to exhaust alternative dispute resolution and you want to make sure that you've made all reasonable efforts to try and settle the matter without recourse to legal proceedings. That's obviously the first, almost self-evident thing, but it is a big issue and it can have an impact on costs, on what order the judge makes down the line, win or lose, in respect of clawing back your legal costs. I'm going to assume that you are bringing your own small claim for purposes of this vlog. Now, big issue actually before you even look at what claim form to fill in is just to check, and of course, as I'm fond of saying on these vlogs, the Bible are the civil procedure rules. They're linked below, but you can just Google CPR and it'll come up. And now the most relevant and probably the civil procedure rule that applies to you if it's a straightforward case is what's called a Part 7 claim, and that refers to the civil procedure rules, CPR Part 7. So for the geeks amongst you, for those who really want to drill into the detail, go and have a look at that Part 7. If you're right on the law in respect of the Part 7 procedure rules, a judge or your opponent, can't really attack you. So that's something that you can have a look at. But it is particularly detailed, and I actually think it's something of the province of lawyers to make sense of the CPR, unfortunately. So you have people like me. You also have, as well as the claim form, if you Google Part 7 form, you'll find a PDF. It's called an N1. As I say, it's probably the form that you're going to be using. And along with that form, there are notes. I think it's N1A. So I'm not going to go into too much the nitty-gritty of filling in the Part 7 claim form, but I will touch on some specific areas as well as the more general areas, because those notes, should be able to assist you. Okay, now, as I say, before actually bringing your what's probably going to be a Part 7 claim, before you bring it, you need to think whether it's the right claim form, and it may not. For example, you need to research this. For example, you could be bringing your claim by means of a Part 8 procedure, and Part 8 is for specific types of claim, and again, in the civil procedure rules, there's Part 8, and the procedural rules are laid out, and the types of claims that you need to bring by means of a Part 8 procedure are laid out. They could be, for example, banks bring possession claims or claims for an order for sale of a property which they've got a legal charge over because someone's defaulted on the mortgage. They bring that by means of Part 8 form, Part 8 protocol procedure, the Part 8 machinery. Another example of Part 8 would be actually contested wills, where you're bringing an Inheritance Act claim. Again, if you drill into the detail of the CPR, you'll find a clause which actually lists all those types of claims that need to be brought by Part 8. Sometimes it's unclear whether it's a Part 8 or Part 7 claim. For example, I had a case recently where I represented a debtor who'd been lent a large amount of money. He hadn't repaid it. His brother had taken a charge, allowed himself to be persuaded to take a charge on his home. Now, if there's a dispute over that loan and the repayment of that loan, it might be better to bring it by means of Part 7. But it is open to an opponent, a claimant, we were the defendants in this case, to bring it by Part 8 because they wanted an order for sale, and the legal charge was very clear on the property. There was no issue over whether or not it was properly signed or executed. We accepted that we'd entered into a legal charge, so there was no dispute of fact, and often kind of a general, if you like, yardstick for deciding whether it's the Part 8, Part 7 claim, if it's not crystal clear because it's not categorised in the CPR, is to ask yourself, is there a big issue of fact? Is there a big issue, a big dispute around the claim? but you're probably going to need advice if you think it is a Part 8, it is a complex, sort of slightly unusual Part 8 type of claim. I don't know, you're probably going to need advice. Okay, but this video assumes that you are just bringing a bog standard Part 7 claim for a sum of money, and perhaps it's just a dispute, a badly fitted kitchen, and you're suing a builder. Television doesn't work, you're being sold a television. I've recently had an old antique case where the antique was sold on, and there was an issue of ownership there. These are the sorts of, I myself, before I was a lawyer, brought a claim against an editor who'd edited a short movie of mine, and he'd lent me a sum of money to help upgrade his editing equipment, and he decided that wasn't a loan that he was going to repay me back. That was actually part and parcel of the charge for editing the film that I'd made. So I sued him and was successful. He didn't turn up at court. So those are the sorts of claims. Usually, though not always, you can specify the sum of money, and you'll see at the top right of the form here, you've got, that's all court stuff. When it's officially stamped, sealed by the court and sent out, they'll fill in all of that stuff on the top right, give it a claim number. You've then got your name, your opponent's name, brief details of the claim. So, that could be, I'm bringing a claim against my neighbour for negligently knocking down my fence and destroying my chrysanthemum bush, which was extremely expensive. I bought it at the Chelsea Flower Show for £5,000 when he was mowing his lawn with his new tractor-sized lawnmower. Okay. Or it might be I lent this person £2,000 and they've in 2011 and they haven't paid me back a penny. It's or it might be a specific area where, for example, with Consumer Credit Act claims, let's say you've been missold a payment protection insurance product by a bank, you actually then need to specifically state the relevant statute that you're bringing your claim under. And again, you're drifting into an area where you might need legal advice if it isn't a basic contractual or negligent or debt issue. If it's not straightforward like that, you probably are going to need some legal advice. But to take the example of the Consumer Credit Act, lots of consumers were fond of bringing claims under what's called the unfair relationships test. That's a particular, relatively recent statute. You actually need to put in the statute in that box there, because that's the gateway through which you're bringing your claim to court. Okay, whereas contract and negligence, it's so self-evident, you don't really need to specify it. It's self-evident. Okay, then you've got the preferred court. The defendant can actually change the preferred court if they want to bring it nearer to themselves, providing they're an individual, not a big corporation. Also, you've got the value box. Now, if you look at the notes here, it invites people to put down a value. They can't put down a value, put down a range, and that range is within small claims, fast track and multi-track spectrums, up to 10,000, 10,000 to 25 to 50,000. Obviously in the small claims track, typically under 10,000, although read the notes about housing disrepair and personal injury claims, you are going to, you're probably going to be bringing a small claim. Now, put 10, if it's 10,000 or under, the court will allocate it to small claims track where lawyers are involved and you don't have the dangers of legal fees. So that value box is important to give a range so that you're indicating to the court whether you think it's a small claim, a fast track or a multi-track case. You see, that's why the notes refer to giving a range if you can't specify the exact value. If you don't know the value, just put I don't know the value. You then put the information in that box on the bottom right hand side. Don't put interest. You claim for interest on top, typically at simple interest, simple 8% interest. So that basically deals with page 1 of the claim form. Let me just check my notes to make sure that I've not missed anything. On the following page, don't worry too much about the Human Rights Act. I've never had a claim where I've had to tick that box, yes. Then you've got the particulars of claim. Now, kind of what's the difference between the brief details of the claim and the particulars of claim? Well, I think I've explained what the brief details of claim box is. It's like indicating what the gateway and the remedy that you're seeking. The particular sort of claim is where you go into the detail and you tell the story. Now, this is how long is a piece of string question. If you've instructed the lawyer, they will invariably produce a very nice looking sort of pro forma, court-friendly, technically correct, particularised details of your claim. You've probably seen it. Here's an example up here, okay? And they will go into a great level of detail about your claim. They'll break it all down into paragraph numbers. And when they sort of tell the story, like on the 13th of January I took out an insurance product with the Royal Bank of Timbuktu, and whilst number one, for £10,000, number one, paragraph number two, as well as the loan, they actually sold me an insurance product on top, and they wrapped it up with the loan to a total of £13,000. In other words, the insurance product was £3,000. Number three, blah, 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 blah. And you might get to a section where, well, I say blah, 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 blah. You then break down the way in which you feel that you've been missold by the bank. And you might say the bank manager didn't explain to me what a lump sum payment protection insurance product was. I didn't realise it would attract interest over the life of the loan. I felt that it was a very short meeting, it was clear that I didn't understand the technical jargon, but no attempt was made to explain that to me. The bank wasn't transparent about the insurance product. I only learned about it much later on when I received my paperwork, and that paperwork was unclear. Please find attached the agreement. Sometimes you can attach the agreement to the particulars of claim. So you rarely, but sometimes you might want to, if there was a critical document, attach a document to the particulars of claim. So that's sort of the lawyer would then go on to, probably in a separate section, to lay out in what way those events, those acts of your opponent triggered a claim in whatever it is, negligence, breach of contract, or in this example here, falling foul of the unfair relationships test, for example, the statutory test. And you would, again, in a kitchen sink set of particularised details of claim, your lawyer would actually look at that statute and look at the various ways in which Parliament has said a bank or a lender can breach the unfair relationships test, yeah? And you'd actually, you know what I mean, marry up the acts with actually the breach. So there might be a section that says, don't quote me on this, banks at all times should be transparent in their dealings with consumers. And you might refer to that particular section. So you kind of like take the statute that or the head of claim that you put in the brief details of claim, and you break it down into a lot greater detail and show how it was that the acts of your opponent had triggered those, breaches, non-compliance with whatever it might be. So that's a full kitchen sink set of particulars. But it's rarely necessary in a way. I mean, if you're bringing your own claim, you're not using a lawyer, you probably don't want to go into that level of detail. I'm running a claim at the moment where both parties did go into that level of detail, did produce quite long-winded particulars of claim, defence, reply, counterclaims, and it's just too confusing. It's very long, covers everything. You don't want to be covering this isn't a job in covering every single crack, This is a case of crystallising your case. And it's important to understand that when you're breaking down the facts you believe give rise to a claim in law against your opponent, you're not laying down the evidence. So evidence is produced at a later stage of proceedings, when you prepare your witness statements, because the witness statement will produce, by way of exhibits, the various documents. So, for example, I alluded to a bank loan document with insurance that's been added, obviously a critical part of the claim. You don't have to include it with your claim form and your particulars of claim, but you might want to, because, as I say, you might, you've got the opportunity in the second bite of the cherry to include it as an exhibit to your witness statement. That's evidence in this instance that the bank lent you money and that they sold you an insurance product, amongst other things. So don't be putting evidence into the claim form, and don't be putting it into particulars of claim. So now, as I say, here's an example of where we didn't use an additional particulars of claim that we attached to the claim form. We just laid out, the client here laid out in basic terms, just in a numbered list, exactly what the story is, exactly what his beef is. So that, where you are a litigant in person, that's as good a way of doing it as any, quite frankly. Better keep it simple and concise. The biggest problem that I find amongst consumers and my clients is they go over the top. They put in the kitchen sink into the particulars of claim rather than being forensic, concise and incisive. It's really important you just lay down the bare bones of your claim. And then you will claim interest. You can put that in the particulars of claim or the particulars of claim box here. It's typically simple 8%. If it's more complicated than that, you think you might be entitled to compound interest or other sorts of losses that over and above the standard rate of interest that the court awards. Once again, you probably need legal advice. Okay, so there it is. You can, just final few things. By the way, if a lawyer, a lot of what's in the claim form is only applicable where you're being represented by a lawyer. So, for example, the legal representative's costs. That is obviously, if you're bringing the claim yourself, you won't put in that box. You won't put a value in that box. Court fee, typically 5% of the claim value. Go online, look up EX50. That gives you court fees. These days, in general, it's worked out as a percentage of the value of your claim. Okay, if you're bringing your claim, if it's a simple, straightforward claim, you can bring it if it's a simple claim, you can bring it money claims online, and in that case you send it to if it's a simple claim, you can bring it by means of money claims online. Okay, that's a lower issue fee of typically 4.5%, and you should send the claim form, or you can do it electronically. So you can also send it, you can also make this, you can do this online with a simple claim. Oh, finally, you should produce a copy for the defendant. So when you post this to the court, you should include 2 copies, one for the court and one for the defendant. If there are 2 defendants, you should actually send 3 copies in the post to the court. Okay, 3 copies in the post to the court. Right, just some final catch-up points. You can bring a claim online, okay? Again, Google, I'll put a link underneath here, but you'll find details and notes of what types of claims fall into the category such that you can make a claim through money claims online, okay? And you can take your claim, progress your claim quite a long way by means of money claims online, but only certain simple, easily quantifiable cases can be brought that way. It does save you a little bit on the issue fee because it goes down from 5% to 4.5% of the claim value. All right. If you're not sure, it's best to send it by post, in my view. If it is a specified sum of money, then you actually have to read the notes, as I say, the Part 7 notes. You have to send it to the Money Claims Centre. It's a certain address. I think it's in Salford. Check, as I say, check the notes. You should send at least 2 copies, one for the court, one for the defendant. If there are 2 defendants, send 3 copies, because what will happen is the court will send the claim out to your opponent once they've received it, and they'll give it a claim number and they'll date stamp it. All right. As I say, if you're not legally represented, then a number of those boxes on the claim form you won't need to fill in. You won't need to fill in the legal costs on page 1. On page 2, down the bottom there, you'll see that you cross out the relevant bit that doesn't apply to you. All of that stuff there at the bottom, I believe, etc., is where you've got lawyers instructed, and that's why it's giving you those alternatives. You'll probably just simply be able to tick through the stuff that just leaves I believe. Okay, so that's in a nutshell how you bring a Part 7 claim. Now, the defendant then has 14 days to respond. They can file an acknowledgement of service, which then gives them 28 days from the issue date. Issue date will be sealed on the claim form itself. You'll get a copy back from the court, by the way. So with the seal and the date on it. So it could be so they can extend, the defendant can extend the period for filing a defence to 28 days from the date of issue of the claim if within 14 days they file an acknowledgement of service. Those defence acknowledgement of service forms are sent out to the defendant after the claim has been issued. Now, they could ask for more time. They might want to get legal representation, and you might find them coming back to you and saying, can I have another 28 days? In those circumstances, it's best not to object and just to accept and to give them an extra 28 days. A lot of consumers don't like doing this, but the CPR is pretty clear on this. You've got to have very good reason, like real prejudice is caused to you for giving your opponent an extra 28 days. But frankly, you probably spent 6 months or a year before bringing this through the courts. An extra 28 days isn't going to make much difference. And you should be giving the defendant full opportunity to consider your claim, to respond to your claim. So there it is, a little bit of whistle-stop tour around the Part 7 claim process and filling in the relevant paperwork. If you need help, then please do get in touch. It's best to email us at info@redwoodlegal.co.uk and actually to give us a paragraph or 2 in the covering email, the story of your claim, and attach any relevant documents. Now, I think this is quite a good thing to do if you're a consumer. You might want to save money by not instructing lawyers and just completing all the paperwork yourself. In those situations, you might nevertheless want a lawyer to cast an eye over the document. So I actually strongly encourage people to try and complete the paperwork themselves, and then perhaps find a lawyer like us to cast their eye over the paperwork. And, we can do that quite simply. If you just send us the draft claim form, the draft particulars of claim, there may not be a separate particulars of claim document. You might have fitted it all into the one box. And then we can tell you how much it's going to cost us to cast our eye over it and make sure you haven't made any howlers before you send it off. Okay, thank you for tuning in, and that's all for today.